Hello, distinguished friends and colleagues. This is Stuart Hamilton, the Pro-Life Activities Coordinator for the Archdiocese of Louisville, Kentucky, serving under Deacon Stephen Bowling. And this is 5 Minutes for Life. We'll take 5 minutes to discuss one topic, one event, or one ministry that affects the pro-life movement here in the Archdiocese of Louisville. Today we will be talking about the Kentucky Supreme Court hearing over the injunction that was placed on the 2019 trigger law. So let me explain this. If you recall, when Dobbs versus Jackson was handed down by the federal Supreme Court, Roe v. Wade was overturned. Well, Kentucky had a 2019 trigger law on the books that went into immediate effect, and the abortion clinic was forced to shut down. Now, they were shut down for about 48 hours until EMW and Planned Parenthood filed for an injunction against the trigger law, claiming that the trigger law is unconstitutional. Well, a lower circuit court judge agreed with the injunction, and so the abortion clinic opened back up. It was open for a few weeks, I forget how long, until another judge intervened and said it is inappropriate and not appropriate for the court to agree with an injunction on a law that has not been proven unconstitutional. So basically the injunction was overturned, and so the abortion clinic had to shut down and has remained shut down ever since. Well, the case has gone all the way up to the Kentucky Supreme Court. And basically, it is a case on whether or not the injunction itself is unconstitutional. Okay, so the court case was heard and the arguments were heard on November 15th. So each side had 30 minutes to present their case, and I'm going to break down their arguments. The first 30 minutes were for the defense of the trigger law, representing Attorney General Daniel Cameron. Attorney Coombs did the argument, and basically he made three strong arguments, in my opinion. First, he said there's obviously not a clear right to abortion in the Kentucky State Constitution, and it is a hotly debated issue. Therefore, the appropriate authorities to make laws to clarify this are the legislators that are duly elected. That's his first argument. Secondly, he argued that technically EMW did not have appropriate third-party standing in order for the injunction to put into place. Now, what this means in technical law is EMW is arguing that women are harmed by the trigger law, but no women themselves representing the harm that's been done to them have come forth themselves in order to establish appropriate standing. So this is a technical legal argument, but as I understand it, he's basically saying that EMW doesn't have the legal right to make the argument for the injunction. Thirdly, he's arguing that EMW is really making an all or nothing argument, saying that abortion is a constitutional right. So if you agree with them on and you allow the injunction to go into place, it will set a terrible precedent for later court cases involving the trigger law, because it will basically make the case that abortion is constitutional. And since that's not what this court case is about, he basically says you should allow for the trigger law to be in effect until the constitutionality of the trigger law is argued. Those were his basic arguments. And then EMW had 30 minutes and they made their arguments, and they said, listen, pregnancy is a medical condition. Therefore, it is covered under rights of privacy in the Kentucky State Constitution. This is the same argument Roe v. Wade made. So they're saying it is clearly an issue that a woman has privacy in medical issues involving her and her doctor, and so abortion is constitutional. They also said because of the close relationship between the abortion providers and the women they serve, they did have appropriate third-party standing to be filing for this injunction. So how did it go? Well, firstly, I have to say that Daniel Cameron's defense, Attorney Coombs, did a terrific job, but he was vigorously tested and questioned by two of the 7 Supreme Court justices in particular. Their line of questioning I could only describe as hostile or contentious. I mean, they were making the case practically for EMW. Now, I could be reading it wrong. You can watch it yourself and see how you feel about it. I'll put a link in the description below this video. But basically, their main concern was that the trigger law was incredibly vague when it came to life of the mother situations. If you recall, the trigger law does make allowances for life of the mother, but the two Supreme Court justices were saying doctors are completely confused about what that means. Now, Attorney Kuhn pointed out the Attorney General's office did send out guidelines to the doctors, but this did not seem to convince these two Supreme Court justices. I have to say that if I were a betting man, I would suggest that the two Supreme Court justices are definitely in favor of EMW and the injunction itself, but who knows? They might have been playing devil's advocate, and we need to, just kind of assess it as what it is. Now, EMW also made their argument. I think that they made their argument well, and they were interrupted less. Several of the justices did ask clarifying questions, but I would not describe the way that they were questioning as hostile in the same sense that the first line of question went. So, what can we expect from this? Okay, first of all, when will the Kentucky Supreme Court let us know whether the injunction is going to be in place or not? We have no idea. It could be a week, it could be 2 weeks, it could be a month, 2 months. I would suggest this, that if they're going to keep the decision really narrow on the injunction itself, it'll probably take less time because they know that this injunction will affect a lot of parties. Either it'll affect the unborn children, or it will affect, if they agree with EMW, the women who are seeking abortion. So I would suggest if it's a really narrowly defined ruling, that it'll take less time. If it's broader and they're going to make some decisions that are going to affect the trigger law itself, then I would suggest they're going to take a little bit more time to discuss it and write their decision. Now, what if they agree with the injunction? Does that automatically mean the trigger law is in the garbage? No, not necessarily. If it's extremely narrowly defined, they may allow for the legislators to respond by making some clarifying legislation about how the trigger law should be interpreted and enforced, and that may set up for a more favorable situation later when the Supreme Court hears the case for the trigger law itself. So that is kind of what we want. It's the best worst case scenario. If they agree with the injunction that they are allowing, though, in a really, really tightly narrow decision for the legislators to respond. So where does that leave us? There's a lot of what ifs, so we need to pray. Pray for all 7 of the justices, all 7 of them, that their hearts would be enlivened by the Holy Spirit with wisdom, and that they would make a decision that benefits both women and the unborn. Now, here at the end, you may notice that popping up here are video options. I have a video option here about my reaction to Amendment number 2 being voted down. I'll discuss what does this mean for the pro-life movement going forward in Kentucky. I'll also discuss how Amendment number 2 being voted down affects this Supreme Court hearing. So if you're interested, click on that video. And if you like what I do here, like, share, and subscribe my videos. Remember, every human life is worth fighting for because every human life has dignity in the eyes of God. I'll see you here next time. God bless.